Why the project is still not completed? The expected completion date has already passed.
Yes, and we are already incurring additional financing costs because of the delay.
Since the end of this week, can you continue to submit this process?
We never agreed to the standard contract in the first place.
Exactly, the contract sum and completion date were never finalized.
But we still completed the project, we deserve to be paid.
You completed the project late.
We completed the project, we deserve payment.
The dispute arises from a construction project between Solid Rock Sdn Bhd, the employer, and the Skyline Building Co. Sdn Bhd, the contractor. On 1st January 2025, Solid Rock issued a letter of intent proposing the project be carried out under its own standard form of contract. However, the contractor did not agree to the proposed contract terms. The parties also failed to reach the agreement of essential matters, including the contract price and completion date. Despite the absence of a finalized agreement, Skyline Build Co. proceeded to carry out and completed the construction works. Following completion of the project, a dispute arose between the parties. The contractor claims that it is entitled to payment for the work completed, while the employer argues that the contractor finished the project late and should be liable for delay damage. The key issue before this tribunal are whether a binding contract existed between the parties, whether the contract is entitled for the payment, and whether the employer is entitled to claim damage for the late completion. We now proceed to arbitration hearing.
Good morning, everyone. I am AQILAH, the sole arbitrator appointed to hear this dispute between Solid Rock Sdn Bhd as the claimant and Skyline Build Co. Sdn Bhd as the respondent. The dispute concerned a proposed construction project where a letter of intent was issued by the client. The parties failed to agree on essential contractual terms, including the standard form of contract, contract sum, and completion date. Despite this, the contractor proceeded with the works. The contractor now seeks payment for the works completed, while the client counterclaims for damages arising from alleged late completion. I will now invite the client to present the case.
Thank you, Madam Arbitrator. The claimant submit that no formal contract was ultimately signed between the parties. The respondent expressly rejected the claimant's proposed standard form of contract. Here the letter of intent made by our company that has been rejected by the contractor. Under Section 7A of the Contract Act 1950, acceptance must be absolute and unqualified. Since the respondent never accepted the proposed term, no binding contract was formed. For instance, the principle established in Law KHAIRUL versus Muhammad Isa 1963 confirms that an agreement subject to a future formal contract does not create a legally binding agreement. Therefore, the respondent cannot rely on contractual right to claim payment. The work will carry out entirely at the respondent own risk. Thank you, Madam Arbitrator.
Okay, thank you, claimant. I will now invite the respondent to present its case.
Thank you, Madam Arbitrator. The respondent relies heavily on the documentary evidence before the tribunal. These are the evidence of the email that I received from claimant. The respondent email dated 1 January 2005 clearly stated that several essential contractual matters remain unresolved. These included the standard form contract, the final contract sum, and the completion period. The email expressly stated that no final agreement had been reached. The letter of intent itself states that no binding contractual agreement shall arise unless and until a formal written contract has been executed by both parties. This confirmed that the parties never intended the letter of intent to create legal obligation. The authority of IYUNIE County Direct Jin Malaysia Berhad versus YC Chin Enterprises Sdn Bhd 1994 supports the principle that where negotiations remain incomplete and essential terms are resolved, no concluded contract exists. Despite the absence of a formal contract, the respondent completed substantial works which benefited the claimant. Under Section 71 of the Contract Act 1950, a party who lawfully performs work for another is entitled to reasonable compensation. Therefore, the respondent respectfully requests payment on a quantum merit basis, dismissal of the payment counterclaim, and the cost of arbitration. Thank you.
Okay, thank you, respondent. Anything to add from the claimant side?
I do, Madam Arbitrator. The claimant submit that the respondent completed the project 10 days later than expected. So the letter of intent stated an anticipated completion date of 15 April 2026. However, the respondent only completed the works on 25 April 2026. Here are the picture of the site on 25 April 2026. As a result, the claimant suffered actual losses. So first, the claimant incurred additional financing costs because the company continued paying loan interest during the delay period. The additional financing cost amounted of 10,000 ringgit Malaysia. So under Section 74 of the Contract Acts 1950, a party suffering loss from a breach is entitled to compensation for losses naturally arising from the breach. So the delay directly caused financial loss to the claimant, and therefore the measures should be awarded. Thank you.
Media Arbitrator may also add, so that although the respondent accused that no contract existed, involuntarily proceed with the project despite knowing that negotiation were incomplete. The respondent was aware that the standard form contract price and completion period remained unresolved. Yet it chose to continue construction after the notice has been given. So under Section 10 of the Contract Act 1950, acceptance may be inferred from conduct. So by commencing and completing the works, the respondent accepts the responsibility associated with carrying of the project. The respondent cannot now avoid liability simply because no formal contract was signed. Furthermore, the respondent never suspended work or insisted on finalizing negotiation before the proceeding. So if conduct fairly demonstrates acceptance of the arrangement, the claimant therefore requests for damage for completion, dismissal of the respondent by claims, and cost of arbitration. I think that's all. Thank you.
Thank you, claimants. I'll now invite the respondent to respond to the statement that has been claimed by the claimant.
Thank you, Madam Arbitrator. The respondent submit that the claimant counterclaim for delay damage must be dismissed. Firstly, the alleged delay was caused largely by adverse weather conditions, which were beyond by the respondent's control. Construction activities are highly dependent on suitable weather conditions. During the project period, heavy rainfall and unfavorable site conditions affected the progress of the work. These circumstances were external events and cannot fairly be attributed to any fault or negligence on the part of the respondent. Therefore, the respondent submit that the delay was not a deliberate failure to perform its obligation, but was caused by factors outside its reasonable control. Secondly, even if the tribunal finds that a delay occurred, the claimant must still prove that the delay differs actual loss or damage. Pursuant to Section 74 of the Contract Act 1950, compensation can only be awarded where loss or damage is proven. The claimant merely alleged that it suffered financial loss and operational disruption. However, no supporting documents such as invoice or the financial statement, bank report, or detailed calculation have been produced to substantiate those allegations. Thirdly, under Section 101 of the Evidence Act 1950, the burden of proof lies on the claimant. It is the claimant who must prove that loss was actually suffered, second, the amount of the loss, and that the loss was directly caused by the respondent conduct. The claimant has failed to discharge his burden. Furthermore, the respondent relies on the case of Tekun Nasional versus Plenitude Drive, Sendian Berhad, where the court held that damage cannot be awarded in the absence of proof of actual loss and quantum. In the present case, the claimant has not produced credible evidence showing that the alleged 10-day delay result in a loss claim. Accordingly, the respondent respectfully submit that the claim for delay damage is unsupported by evidence, lack proof of causation, and must therefore be rejected. Thank you.
Madam Abdul, the respondent respectfully submit that no valid and binding contract was ever formed between the parties. Firstly, under Section 78 of the Contract Act 1950, acceptance must be absolute and unqualified. In this case, the respondent did not agree to the government proposed standard form contract. More importantly, essential terms such as the contract price and completion date were never finalized. Therefore, there was no meeting of minds and no valid acceptance. Secondly, the letter of intent was merely an indication of an intention to negotiate. It clearly stated the project cost, completion date, and contract term would be finalized if mutual agreement, and that non-binding contract will arise until a formal written contract was executed. Furthermore, under Section 30 of the Contract Act 1950, agreement with uncertain and key term or what? Since key term remain unresolved, not enforceable contract existed between the parties. Finally, although no contract existed, the respondent completed substantial work that benefit the claimant. Under Section 71 of the Contract Act 1950, a person who lawfully performs work for another is entitled to reasonable compensation. The respondent therefore submit that while it cannot be held liable for delay damages, it is entitled to payment on the customary basis for the value of the work completed. This position is supported by Diamond Development Sdn Bhd versus Meju Liu Chintek 1981, where the court held that an agreement subject to a future formal contract does not create a legally binding contract. Accordingly, the respondent respectfully requests that the claimant counterclaim be dismissed and the reasonable payment be awarded to the respondent. Thank you, Madam Arbiter.
So we have heard from both sides, which is the claimant and the respondent. So now I have one question for the claimant. If your own letter of intent expressly stated that no binding contract would arise until a formal contract was signed, on what basis do you claim delay damage?
Thank you, Madam Secretary. Although a formal contract was not executed, the respondent conduct in proceeding with the word demonstrate acceptance under Section 8 of Contract Act 1950. Therefore, the obligation arises through conduct.
Thank you. So now, one question for the respondent. If no contract existed, why should the respondent be entitled to the payment?
Madam Arbiter, because the claimant received and benefited from the completed works. Under Section 71 of the Contract Act 1950, reasonable compensation may be awarded even where no formal contract exists to prevent unjust enrichment.
The claimant respectfully requests the measures for the delay and dismissal of the respondent pay claim.
The respondent respectfully requests payment on the quantum merit basis and dismissal of the claimant counterclaim. Thank you.
Okay, so we have heard from both sides now. Having considered the submission and evidence of both parties, I find that the parties never reached an agreement on essential contractual terms and therefore no binding contract was found. Accordingly, the claimant's counterclaim for late completion damage is dismissed. However, as the respondent completed work from which the claimant benefited, the respondent is entitled to reasonable compensation on a quantum merit basis. This concludes the arbitration proceedings. Thank you.